Okay, I think we're live streaming now. So this is State of Kansas v. Stephen A. Stone, docket number 128383. Will you state your appearances, please?
May it please the court, Grace Tran of the Appellate Defender Office on behalf of Stephen Stone, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you. So we are here today for oral argument. We thank you for accommodating our request. We'll just jump right in. How much time would the appellant like to save for rebuttal?
Your Honor, may I please request 3 minutes?
You may. So you can see me. So when you have a minute left, I'm going to give you a 1 minute signal with my finger and hopefully that will let you know. Okay.
Okay.
All right. Anything else to take up before we get started?
I don't believe so.
All right. You may begin. Thank you.
May it please the court, Grace Tran of the Appellate Defender Office on behalf of Stephen Stone. We are here today to discuss Stephen Stone's 6 aggravated robbery convictions. And Your Honors, I plan to focus my arguments on the prosecutorial error and the sufficiency arguments as it relates to the dangerous weapon elements of aggravated robbery, because those 2 issues go hand in hand. So first, the prosecutor misstated the law in this case as it relates to the dangerous weapon element of aggravated robbery. During closing arguments, the prosecutor told the jury that the note was sufficient in this case to prove the dangerous weapon element of aggravated robbery. And the note in this case that the man displayed, testimony varied, but said something to the effect of, give me the pills or I will shoot. And the prosecutor argued during closing that this was sufficient to prove that the man in this case had a dangerous weapon. And this is a misstatement of the law because the dangerous weapon element of aggravated robbery and the threat of bodily harm element are separate. And this note was a threat of bodily harm. Yes.
I apologize. This is Judge Klein. As I mentioned, I'm on my phone, so I apologize if it's difficult to hear me. It's my understanding that the prosecutor made that statement in his initial closing, but then in rebuttal closing, fixed it and said, hey, I'm not saying that somebody is going to kill somebody with a paper cut. We also have to have, some conduct. It's the illusion of the gun. And then he also mentions, potentially having a hand in the pocket or taking some action that would indicate a gun in addition to the note. Is that a fair statement, or do you agree with that correction?
Your Honor, the prosecutor did revisit the issue of, what was sufficient for the dangerous weapon in rebuttal closing and talked about, putting a hand in a pocket or a bulge in the pocket or even just having a pocket. But ultimately, I think that the focus was still at that point on the note and what the note led the people that it was displayed to believe. And so I don't think that quite got to the point of fixing the issue of telling the jury originally that the note was sufficient, because the focus was still on what the people reasonably believed. And I think that from the cases, it's just not enough to say that they reasonably believed that there was this dangerous weapon in the absence of something else. And sure.
Right. And I guess my question is, if we have a mistake in the initial closing, a mistaken statement, and then that statement's corrected in rebuttal, is that enough to render the initial error harmless? I mean, can you speak to that point in terms of, whether or not the statements, and I think you were kind of getting to it, but I want to direct you to, were the statements in rebuttal closing enough to correct that initial error? And if you say they're not, then why not?
Your Honor, no, I don't believe that the statements in rebuttal were enough to correct the initial error, because even though the prosecutor made the distinction later of, it's what the witnesses reasonably believed due to, a hand in a pocket or a bulge in a pocket, and they referenced even just having a pocket. So I think you can still, that statement can still comport with the first statement that they originally said in their closing, which was that the note was enough. Because if you're telling the jury the presence of a pocket, that the person had a pocket that a gun could possibly be in with nothing else, that's pretty much the same thing as saying that the note was sufficient in this case. So I don't think that that was enough to fix the misstatement in the initial closing argument. No.
Okay.
If we-
And do you know if the affidavit of probable cause was admitted as a trial exhibit? I can't find a list of trial exhibits in the record.
Your Honor, off the
If-
top of my head, no, I am not sure.
Okay. So are we the only evidence admitted at trial that during the two robberies at issue, that there was any conduct in addition to the note is just the officer's statement, basically that when he initially talked to the victims, they told him that. Is that correct?
I think that that is correct. Yes.
Okay. And then those victims testified at trial and said they didn't see a gun or anything indicating that they saw a gun, correct?
Right. For the witnesses for counts 3 and 4, those were the witnesses that we raised in regards to the sufficiency claim. Yes, they were explicitly asked and explicitly testified at trial. No, we did not see anything that made us think that there was a gun present.
Okay. And so just to clarify, the only evidence that there was conduct in addition to the note that could lead someone to believe there was a gun was just the officer's testimony?
Yes, Your Honor. I think that that's
Okay.
correct.
Thank you. I just want to clarify the record.
Yes. And so, coming back to this discussion about the dangerous weapon element, I think that it can't be the case that the threat of bodily harm, in this case, the note saying, give me the pills or I'll shoot, that can't be enough to constitute the dangerous weapon element, because if that is enough, it virtually erases the distinction between robbery and aggravated robbery. Because in robbery, we have the same element of the threat of bodily harm, and in aggravated robbery, the same. And it's easy to imagine, a circumstance in which virtually any threat of bodily harm, such as, for example, if the note said something like, give me the pills or I'll harm you or I'll hurt you, that there could still be a reasonable inference there that maybe that person has some kind of weapon that they would harm me with. And so if that is enough, if the threat of bodily harm is enough, then that erases the distinction between robbery and aggravated robbery. And so courts construe statutes to give meaning to every word in the statute. And so here there's this element, armed with a dangerous weapon. And I think sort of this conflating of these two elements renders those words without meaning, as well as leads to an absurd result, because we could have basically every robbery in this case become an aggravated robbery. And so moving on to the issue of harmlessness, this misstatement of the law was not harmless. So as we already have touched on, for 2 of the counts, there were witnesses who testified explicitly that they saw nothing, that they saw no indication of any physical presence of a gun being present. And for the remainder of the witnesses, there were real factual questions that the jury would have needed to determine in this case. I think a couple of the witnesses testified that they possibly had seen a gun, or there was a hand in the pocket that made them possibly think that there was a gun present, as well as, maybe a handle of a gun. And in one of the charges, one of the witnesses thought they saw something and the other one said that they didn't. And so basically telling the jury that this note is sufficient, the threat is sufficient, told the jury, you don't have to resolve those factual questions. You can just find that if there was the note here, if there was the threat, that is sufficient for aggravated robbery, for the dangerous weapon.
Counsel, if I can chime in for a moment, but in their case law that if there's a note coupled with some sort of menacing gesture, I think is language used, which does appear to exist in counts 1, 2, I guess it'd be 5 and 6, that is sufficient to support aggravated robbery, even if there is no gun present.
Your Honor, there is case law that says that, yes, that threats of harm plus, yes, like a hand in a hoodie pocket that people mistake to be a gun. I think the inquiry really is what the person reasonably believed, or what the impression was of the person that is witnessing this. And still here, I think there were factual questions where people thought that they possibly saw a gun, or one person saying they did, and one for the same charge, one witness saying they thought they saw something, one person saying they didn't think they saw something. And so I think still, even though some of this could have been, enough to say there were still these factual issues that the jury needed to resolve, and that was effectively communicating to them that they did not have to resolve those questions, that the note was enough. And so moving to the sufficiency issue, which we've touched on, for counts 3 and 4.
Before you move on, I think you raised the issue of the term terrorize.
That's correct.
Error. Did you have any comments on that?
Your Honor, I think that we would just say that calling what happened in this case, or referring to the words terrorized and terrorizing, was not a fair comment on the evidence, and was just an attempt to inflame the passions of the jury and to garner sympathy for the pharmacy employees in this case. And so our argument was that that was not a fair comment on the evidence as well.
But on that, I mean, isn't the jury instructed in this trial and really every trial that, the comments of counsel are not evidence and they are only to consider the evidence? What impact would an instruction like that have on reversibility?
Your Honor, I think that when we look at sort of the totality of everything in this case, an instruction saying that the remarks of counsel aren't evidence can't really unring that bell for the jury of starting up the very beginning of the trial. I think it was the beginning of opening remarks and then the very beginning of closing, sort of bracketing this trial with that, as well as, sort of the other prosecutorial error when it comes to misstating the law, that sort of the totality of that can't really be undone by this jury instruction saying that remarks of counsel aren't evidence.
You have about a little over 1 minute if you want to move to sufficiency.
Sure. So with the sufficiency question, we've discussed it a little bit, but basically in counts 3 and 4, the witnesses to these robberies testified that they didn't see any evidence that there was any gun in this case, that nothing physically made them think that. And so because of the discussion we've had with regard to the fact that the threat of bodily harm can't be sufficient for the dangerous weapon element, that is not sufficient to constitute a dangerous weapon, and therefore the evidence was not sufficient to prove aggravated robbery on those counts. And so for these reasons, we would request that that the two counts 3 and 4 be vacated, and that Mr. Stone receive a new trial on the remainder of the counts. And unless there are further questions, I would submit the rest of the issues on the briefs.
Anyone have any questions? All right, thank you. All right, Mr. Gillette, whenever you're ready.
Thank you, Your Honor. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will address the two issues that opposing counsel has addressed here today, unless this court has questions on the others, and I'll address them in the same order. First, on the issue of prosecutorial error, the state maintains that the prosecutor in this case did not misstate the law. When this record is properly viewed in context, the prosecutor correctly stated the law and then transitioned into a discussion of the factual evidence that was presented in this case. And it is at that point in time where the complained of remark occurred.
Counsel, are you claiming the statement, the note is a dangerous weapon, was a correct statement of the law?
I'm not claiming that as the correct statement of the law. No, Your Honor. What I am asserting is that it is precedent from our Supreme Court that where a prosecutor's complained of statement is subject to a reasonable, better understanding, contrary to the defendant's interpretation of that statement, then the defendant should be denied relief because they are failed to actually establish the error that they're claiming. They're claiming that this was an error of law. The record does not support that. I think this court.
So do you agree that more than a note is required? We need a note plus some conduct, like Judge Gettler described, some menacing gesture, some hand in the pocket, something to indicate there is actually a weapon in addition to the note?
On the question of sufficiency, it would require viewing the circumstances from the victim's point of view. The note alone, just displaying it, would not amount to a deadly weapon. And that is exactly what the prosecutor intended, as he clarified in rebuttal closing here.
But I mean, it applies to both issues. I just want to know your position because it applies to both issues. You agree that the note alone is not enough. You have to have some gesture, conduct in addition to the note?
Correct. There has to be some other circumstance beyond just the simple display of the note itself.
Well, what
Okay, and then-
circumstances? So what existed as to counts 3 and 4 beyond the presentation of the note that would meet that standard?
Regarding counts 3 and 4, the state acknowledges that the two witnesses that were victims in that case did not see a gun. However, we do take issue with opposing counsel characterizing the record as containing only the testimony from Detective Reynolds in support that those witnesses had made prior inconsistent statements that they believed there was a gun because there was a hand in a pocket for at least some time. That evidence is in the record. The defendant ignored that entirely in his initial brief and then characterized that as the exclusive evidence here today. In addition to that evidence, though, this court can look at the fact that the two victims in that count, or in count 3, they acted based upon their belief or fear that the threat that was conveyed in the note, that there was a gun or there'd be a shooting. They acted in conjunction with that. Their fear was real. There's also video evidence that was admitted in this case that would corroborate what Detective Reynolds had said and what he testified to, because the video showed that the defendant obscured his right hand, which was not holding the note, until he took possession of the hydrocodone he demanded. There was also evidence of the defendant's modus operandi here. There were 6 counts. The modus operandi was so clear that this court can absolutely consider that regarding the sufficiency as well. It's so clear that every single robbery occurred within, I believe it was within about a 9-day span, almost month to month, beginning in August with breaks in September and October.
Wouldn't we be required, though, with the inferences to impute that on the knowledge of the victims in counts 3 and 4? Wouldn't they have to be aware of all the circumstances that occurred in the first 2 incidents?
Yes, the victims would have to be aware of that, and that was what I wanted to try to convey is that Detective Reynolds testified that these victims had given a prior inconsistent statement that it was his testimony that they reported believing there was a gun because the defendant had a hand in his pocket. Video corroborated that account. I think that the best way to characterize the two victims not testifying that they didn't see a gun, I think that's true, but that doesn't mean that they didn't believe there was one based on the defendant's actions, including putting his hand in his pocket, as Detective Reynolds conveyed. Count 4 was much the same. In that case, the individual specifically said that the defendant had a gun, would shoot, that the one individual didn't see a gun or any specific indication of one, though he thought the defendant may have had one concealed in his baggy clothing. Yet again, the video corroborated Detective Reynolds. It showed the defendant concealed his hands in his hoodie after putting the note in his back pocket. Again, the victims acted consistent with believing that there was a gun or a dangerous weapon. They complied promptly, virtually immediately. The other individual, the victim in that case, explained that he believed there was a gun based on the note and act accordingly, quote, just because he just wanted to get him out and make sure no one else got hurt or anything. And in addition to all of that, I would also point this court to the fact that once the defendant's home was ultimately searched, a gun was found. So taking all of these circumstances together, they individually all point towards one thing, and that is that the defendant had a dangerous weapon in each count. And the only two that are challenged on the sufficiency are, again, our counts 3 and 4. I'll return back to the prosecutorial error argument. Again, I think that in context, this court can look at this and see that this was not a prosecutor that was trying to misstate the law. He was not trying to play games with the law or pull punches about the law. He was trying to argue the evidence here, the evidence that was shown here. Again, I think that it's possible to interpret this argument as the defendant has, but that does not demonstrate error. The mere possibility that the argument could be interpreted that way, contrary to a better interpretation that is supported by the record, does not establish error.
Counsel, what's your response to the argument that the corrective statements and rebuttal closing don't quite get there because the prosecutor says the gun's the object, whether he put his hand in his pocket, whether he had a bulge in his pocket, whether he just had a pocket that could house one, he led them to believe he had the gun. And so the statement that just having a pocket that you could put a gun in is also, not necessarily a correct statement of the law, that you do need something more than that. So what's your response to that argument that corrective statement isn't enough and still continues to misstate the law?
I would respectfully disagree. The corrective statement in the at page record volume 9, page 131. The point that I would emphasize is that where the prosecutor argued regarding the notes, they all alluded to, I have a gun. I have a gun. That is the object. Whether he put his hand in his pocket, whether he had a bulge in his pocket, whether he had just a pocket that could house one, he led them to believe he had a gun. And they reasonably believed he had a gun. That is what I have to prove, not that he actually had a gun. And the only portion of that I think that could even come close would have been the comment about
whether he had just a pocket that could house one.
Right,
Yeah.
whether he had just a pocket. But again, that goes back to the testimony, and the witness's first name was Gunther. He testified that based on the defendant's choice of clothing to wear baggy clothing and have a large pocket, Gunther believed that the defendant could have a gun in that pocket. So again, it's not just the pocket. It was what was conveyed to that witness by defendant's behavior. Again, that witness had made a prior statement to Detective Reynolds that he disclosed during the investigation that was contrary to whether he believed that there was a gun or not. He had said that he did based on defendant's actions. And again, I think that the evidence supports those. But that corrective statement alone isn't the only thing that supports a finding. So we don't think that there was error. We believe that the corrective statement was sufficient on its own, but even if not, there is still the issue of harmlessness that arises. If I could, I'll hold off on that for just a moment and touch on the terrorized and terrorizing, the two single words. Judge Bolton Fleming, I believe you asked about this specifically, and the two comments came at totally different times. One was at the beginning of opening statement. The other was in the beginning of closing argument. The state has a couple of arguments to this end. First, it is the state's position that the defendant has utterly abandoned any claim of prosecutorial error regarding the use of terrorized or terrorizing. They refuse to engage in any analysis beyond mere conclusory statements of how or why those words on their own, used one time apiece, were actually improper here, or were in any way intended to inflame the passions or prejudice of the jury or distract them from the evidence. Controlling case law gives prosecutors wide latitude in their ability to make closing arguments, and that includes dramatic theatric language that is permissible. There's even room for rhetoric in eloquence, and modest spectacle is some of the case law has recognized. That's what the prosecutor was doing here, and as the state also set forth in its brief, terrorized or terrorizing is almost verbatim. When you look at those definitions, that is almost verbatim the impact that an aggravated robbery has on a victim. So we do not believe that there's even been error established there. But regardless, a couple of things to note regarding about harmlessness. The two errors, or 2 to 3 errors that are claimed here, they don't actually connect with one another. I think this court can consider the lack of defendant's objection. The jury was also properly instructed on the law, including that the arguments of counsel are just meant to help. Again here, the evidence in this case was compelling. It wasn't only strong on its own. It wasn't just a thorough investigation that included everything from exterior videos, interior videos, testimony, poll cams, a home search. It all pointed to the defendant having a clear modus operandi that was undeniable. Evidence was clear that he had the opportunity. His vehicle was tied directly to multiple scenes. He was engaging in a scheme to swap out license plates, to apply stickers to his car to try to change its appearance, to hide what he was doing. One of those license plates that he tried to dispose of was recovered. A bottle of hydrocodone, an empty bottle, was found in his attic that he should not have had access to. And again, there was a gun found in his house. And the point is, identity was the issue here. And that's where everyone's focus, particularly the defendant's, was below. And the evidence of defendant's guilt, particularly his identity, was overwhelming. Are there any other questions on those issues? If there are questions on any others, I would welcome them. I don't necessarily see any, but I can't see Judge Klein. I know issue 3 was a little bit unusual here. But again, I'll leave that as argued on the brief, that whatever risk there was there regarding the mistrial was mitigated into being eliminated by the district court's approach here. All
Are
right.
there any questions?
I don't have any more. Thank you.
All right. Thank you all very much. The state would respectfully ask that the defendant's convictions be upheld.
Thank you. All right, so the appellant has 3 minutes. You may proceed.
May it please the court. Your Honor, we would respond briefly to the state's characterization of Detective Reynolds' testimony in terms of the assertion that was evidence that those witnesses had prior inconsistent statements that they did in fact see a gun. And respectfully, I don't think that that's what the detective was saying in his testimony. So the detective was asked, first the detective says there was only one incident where there was reported a gun being seen. And then he was asked, did all of the others describe fearing that there was actually a firearm? And the detective said they did. It was described that the suspect had a hand in the pocket, and he went on making them believe that they actually had a gun, as the note indicated. And I just don't think that that's enough that was sort of a general description of what the witnesses writ large had said to him about fearing a gun, which, some of those witnesses in this case, did say that they feared a gun. But I think that doesn't contradict the explicit testimony of the 3 witnesses for counts 3 and 4 that testified that no, they did not in fact see anything that made them think that there was a gun. So I don't
Counsel,
think
why does that conflict not create a question for the jury? We've got an officer basically saying, hey, when I interviewed these people at the scene, that's what he's alluding to. They all said that because of his hand in his pocket and the note, we thought he had a gun. And now at trial, they're saying, no, we don't remember seeing a gun. So can't the jury weigh the credibility of the witnesses to determine, which statements were more credible as to whether or not, the way the hand was in the pocket indicated there was a gun?
I just think that the sort of generalized nature of this testimony, it wasn't like the detective had gone through and said, Nicole and Jennifer and Gunther, they thought that they saw guns in this case. It was just sort of them writ large. And I don't think that that's enough to actually counteract what the witnesses actually said in their testimony. And for those reasons, we'd ask that Stephen Stone's counts 3 and 4 be vacated and the remainder go back for a new trial. Thank you.
Thank you both for your terrific briefing and your argument today, and we'll take this matter under advisement and issue an opinion just as soon as we possibly can. So